Good afternoon, everybody, and welcome to today's webinar on applications under Schedule 1 to the Children Act 1989 in the time of COVID-19. I'm delighted to introduce our guest speaker, Claire Heppenstall from 1GC Family. Claire has particular expertise in dealing with Schedule 1 claims, that's financial provision for children of unmarried couples, and also advising and representing clients in relation to child support issues. Dealing with both children and money work allows her to assist the private client across most areas of dispute that arise during difficult family breakdowns in a highly effective and pragmatic way. She acts in all levels of court and is frequently instructed in cases where Queen's Counsel is instructed on the other side. She is also an arbitrator qualified to adjudicate in both finance and children's cases under the IFLA scheme, as well as conducting ENE, that's early neutral evaluation, and private FDRs. You'll note on the webinar screen that there is a chat panel where you can comment and also raise questions. So please feel free to do that during the webinar, and we will pick up any points after Claire has spoken. Okay, over to you now, Claire.
Thanks, Graeme. Hopefully I will now share my screen. Good. So applications under Schedule 1 in a time of COVID. And I think really circumstances are so extraordinary at the moment. It's really unprecedented what we're all living through. And thinking about the old saying that absence makes the heart grow fonder, the likelihood is that the opposite may well also be true of too much time spent together. Interestingly, evidence coming out of Wuhan, which started lockdown first and has come out of lockdown first, obviously, illustrates that domestic violence incidents in lockdown tripled in number compared to the same months in 2019. They also saw that once lockdown lifted, that there were a record number of divorce petitions filed, and that family lawyers in China were reporting a 25% uptake in new cases. In the UK, sadly, we've already seen reported in the press that domestic abuse helplines are up 50% in terms of call volumes during lockdown. It's clearly putting a lot of pressure on relationships. And so the prediction must be that more family breakups are going to occur. And because cohabitation relationships are obviously easier to end because there isn't the financial ties to sever, they're more vulnerable potentially to that likelihood. And just in that regard, it is important to think about how many cohabiting couple families there are.
Well, Claire, I was just going to add at that point that yep. I think it is going to be interesting to see how all family relationships fare post COVID-19 and how families in the UK have compared with families in other countries, because we know the culture is very different, and I don't know how we compare to China or other countries. It's just something we're going to have to see. But my own experience of practicing during COVID-19 has been that the need for lawyers has been very much present. And it's increasing as the situation changes, as the lockdown eases. So I think it's just a question of the situation emerging, but I do sort of agree with that trend.
Okay, so thanks, Graeme. In terms of, and the point is looking at cohabitation families as a grouping. The most recent statistics are from 2018, and the number of families have obviously continued to rise. Cohabiting families are the second largest family type at 3.4 million. That's just under 18% of all families, followed by 2.9 million or 15% being lone parent families. And you'll see from the statistics that nearly 50% of children born are born outside of formal marriage, civil partnership relationships. And that's a rise year on year. As we can see, in 2015, it was 47.7. And it's also the case that a third of this in 2014, but no doubt the trend continues, 33% of births to British-born mothers were to mothers in managerial or professional roles. And so just have those statistics in mind.
So I was just going to interrupt again, sorry.
Oh, sorry.
And just say, because some people watching this may know that I'm someone who has campaigned for many years for cohabitation law reform as part of my work for Resolution and also as a commentator. And I think it's fair to say that these demographics were pointing to an increase in the need for advice on Schedule 1 claims in any event before the lockdown. And it will be interesting to see to what degree this is accentuated as we come out of the lockdown, as we know that people found themselves in difficult circumstances at the time the lockdown was imposed. Back to you.
Yeah. And there's, as Graeme has indicated, despite the Law Commission research and recommendations about reform that should occur, there's still this ongoing misconception that persists amongst many cohabiting couples that they're common law husband or wife and they've got some sort of remedy, and of course they don't. Absent claims under Talata, they've got no rights for financial support, and that often comes as a shock. And so hence the recommendations that there should be change. But there's, those are a number of years standing now. There's just no political will, given everything else that they're dealing with, no doubt, to bring any changes in that regard. And so for many cases, obviously the CMS, Child Support Agency, is the first and last stop, which will determine the amount of support that may be payable for a child. And that deals with parents with income, paying parents, gross income of up to 156,000. But one shouldn't forget about options under Schedule 1, as Graeme's indicated, because although it may not touch a large cohort of separating cohabitees because of the income limits, don't forget about it as an alternative. Obviously, top-up awards are only available once you've got your maximum assessment in place from the CMS, but you also can apply for school fees, provision for a disabled child, or if you've got a parent or child absent living outside of the United Kingdom, university provision, etc., etc. But also there's the capital provision you need to think about, lump sum awards, settlement of property or transfer of property. And it's just important, I think, to have these potentials in your mind when you're seeing people coming to you for advice, because often I think part of the problem has been that previous cases have been limited to very big money cases.
So I was just going to drop in on that point where you're saying not part of the solicitor's daily diet, and just sort of give an overview of what I found during my career. And I have to say that I agree with your comment a couple of slides ago, that for many people, it just seems the CMS is the stopping point, and people don't think enough about that. And I'm not just talking about the lay public, but also practicing legal professionals. And I think this is due to a lack of awareness, not just about the state of law, but also the ability that we have now, I think, to run Schedule 1 cases much more than we did in the past, for example, because incomes have gone up or property prices have gone up. And I think it's this lack of awareness that we really need to be concerned about.
And I think, as Graeme says, it's also the fact that it tends to be the big money cases, the fabulously rich, which tend to attract attention, and therefore you sort of think, oh, well, it's only those sorts of cases that are appropriate. And part of this webinar is about making you think and showing you some cases where that wasn't the case, and showing you the judge's willingness to be quite proactive in terms of meeting need, absent it being a big money case. I mean, there's always a concern that judges outside of London or large metropolitan areas aren't going to be so familiar with it, but obviously once you take them through the guidance, they are willing to engage in it. So the message we're trying to give you here is don't be put off. and think about it when clients come in to see you.
I think I'd probably just go one step further than that, for as far as solicitors are concerned, is that, well, my view is if we fail to advise on these sorts of things, we could potentially result in a negligence claim. So we need to be alert and aware in respect to these petitioner claims, and that's key. And as we have learned counsel here, it's just worth to say that it is very useful, often at an early stage of a case where you're not sure, to check back and get early advice from counsel to see if these claims are worth running, because obviously we have to bear in mind proportionality and validity of making these claims, but missing it out completely could land us in some difficulties later on.
So just looking at then to remind you of the criteria applied by the court under Schedule 1, it's slightly more limited obviously than under the Matrimonial Causes Act. And you know, the court is very much looking at, the catch-all umbrella of all the circumstances, income earning capacity of both sides, financial needs and obligations of both sides, including second families that may be with one parent, particularly the paying parent, financial needs of the child, income and other resources that the child might have, which is obviously in most normal cases nothing, any physical or mental disability of the child, the manner in which the child is expected to be educated. Now, interestingly, what you don't see there is the welfare of the child, surprisingly, but it's been made very clear that welfare considerations, although are to be implied, they're implicit, but they're a vital consideration to be applied by the court. Orders have to be for the benefit of the child and are time limited, normally up to the age of dependency. Although just pausing there, I would just mention there has been a recently reported decision of DN and UD, where, which is 2020 EWCA 627, where the court did allow provision of a housing fund to last post a child attaining the age of majority and not being dependent, on the basis of exceptional circumstances, a fabulously wealthy case, so not so relevant here, but in circumstances where the assessment was the child was likely to be subjected to pernicious financial abuse of control by the paying parent. So that's one reported case very recently, which changes the time limited aspect, which is been thought to be the case. Principles of allocation. So, you know, this is not a divorce case by the back door. Courts are clear. There's no concepts of sharing or compensation. It's referable to needs of the child. So be careful. And it's often a real issue with the paying parent, which is often the father, that particularly where you've got income claims as a carer's allowance, that there's somehow dressed up payments for the wife akin to what would be available under the Matrimonial Causes Act, but one has to be very careful about that. It's referable to dependency on the child, of the child on that parent. In the majority of cases that we're talking about today, that's unlikely to be a factor unless income is over 156,000. So looking at the approach, Re-P was the first time the Court, this is a 2003 case, was the first time the Court of Appeal had given guidance on the appropriate approach to assessment of a claim. And it was in that case that Lord Justice Thorpe made it clear that, although, as I've indicated, the child's welfare wasn't in the criteria, he said, nevertheless, it's a constant influence on the discretionary outcome. And that's the case I'd refer you to Justice Bodie's judgment, because he gives a really excellent summary of the guiding principles that you have to work out and follow in order to work out what's the appropriate award. And, you know, looking at what are the proper housing needs, is a lump sum required for furnishing, refurbishing and moving costs? What capital items can be properly claimed? Are there capital costs involved? So it's being quite forensic about the claims that are being maintained and put forward. And clearly the standard of living of the father, of the parties previously, but also the standard of living of the father currently, and his resources is going to inform the decisions. But the stress was placed on the fact that it's the welfare of the child which will be the trump card. And J and C 99, that was a previously reported case. This was the first of the lottery cases where the father, I think, had won 1.2 million. The mother, they'd separated when the mother was pregnant, and so the father was trying to make out that the child wasn't wanted and hadn't been planned. And the decision of the court was making it very clear that why should the state pay if this father was now in a position where he was able to pay, whereas previously he might not have been. And why should there be such a differential between the standard of living between the father in his newly elevated situation and the mother? And so she was awarded a substantial housing fund and a car, and costs to assist her in that regard, capital costs. One case that I think, there we are, the house comes in, is a really interesting case, I'll just get all the pictures up, is DE and AB. Because particularly in the lower, middle income cases, this is an interesting one. It is really worth a read, because it's a classic credit crunch case. By the time of the hearing, the mother had lost her job. She had a huge mortgage. She'd previously been in the city. I think she had a large mortgage in her property. She had huge amounts of debts of over 110,000. Meanwhile, the father had been made redundant previously, but he'd set up in business which was still fledgling and wasn't earning a huge amount. And certainly he was telling the CMS that it wasn't earning much more than 20,000, albeit that wasn't the finding of the court. He also had a huge mortgage on his house, so there was limited equity of about 360, and I think his mortgage was about 700,000 or something. But what the court was saying there was that both parents were being completely unrealistic, and that both of them couldn't stay in their houses, and they would have to downsize. But because the child was in such need, that the father was going to be required, out of the limited amount of capital that he had notionally, to give 250,000 of that as a housing fund, on the basis that, of course, that was money that he would get back once the child had finished its dependency and reached the age of 18 and finished university. So the court really, I think, neither parent impressed at all. This is a father who hadn't wanted the child in the first place, wasn't taking up much contact, had a limited relationship. He'd depressed his income for CMS purposes. And so, the court was really making it clear that, notwithstanding his attitude, this child, they had a child together, and therefore the child had to be supported. The mother didn't get all her debts clear, but she got 40,000 towards her lump sum, because it was felt obviously appropriate. The father couldn't be wiped out entirely. And so he was left with 68, which would give him the ability to put down as a deposit on a more modest property. So I think this is a really interesting case for what might be described as a middle-class family living beyond their means, and the court looking at it from the child's welfare perspective and saying, a pox on both your houses, this is what's going to happen in order to ensure that the child's needs were met. So it's a good one to read, just from that fact alone, to see Mr. Brown taking quite a firm approach.
I was going to say on that, Claire, that the numbers involved, and that was actually 2012, I don't think the numbers involved are that dissimilar to the numbers that we might see in everyday practice. So I think that we often look at the two, I think it's the repeat case, and think, well, it's just wealthy fathers, but those numbers involved there are the sorts of numbers that we might see, and we need to think about what happened in that case.
Absolutely. Because the point was the mother, in going back to that case, she was given $250 for a housing fund. She had equity in her property, and the court was saying, well, you can put equity into the new property, but you can also use some of your equity to clear down your debts. So the court was being really quite pragmatic in its approach. And Graeme's right. Look at the sums involved. That is precisely a lot of bread and butter work for high street solicitors. So that's why these sorts of cases are really important to have in your arsenal, just to remember and to remind judges whether they think it's all fabulously wealthy clients. It doesn't need to be. And this is another, REM 2014 is another one which is in the same sort of situation. Mother did own a house, but she was on benefits, tax credits, etc. Father had remarried and he'd moved to work in Switzerland, and he wasn't a high earner by any stretch. He'd had 3 more children, so he'd really moved on. And look at the figures involved. He had a modest 137 in a bank account that was free, surplus if you like, a further 60,000 in a long-term investment. And so what the mother was trying to do was basically wipe him out and saying, well, that's all free and available, and I need it to clear my credit card debts, and to refurbish my property. I want to buy a car, and the court rejected that because it wasn't felt appropriate to leave him with nothing. And so she was awarded 44,000, which was enough to clear her debts. And part of the reason it said that she'd run up debt was because he hadn't, it had taken a long time for her to get financial support from him on an appropriate basis, because he hadn't complied with assisting income provision for the child. So, she was given 44,000 towards her debt, and it was felt that looking at it overall, that was basically about 1/3 of the father's capital free that he had available to use, but it wasn't appropriate to wipe him out entirely. But again, it's an important case just to remember and to think about, because it's about debt clearance, and it's about where, it's not a big money case. But the welfare of the child required the mother to have some debt burden alleviated, and so that was the approach that was taken. But it was what the court was saying here. It's important to look at the impact on both parents. And clearly this man had moved on. He did have another family that he was supporting. So it was about the balance being struck to assist the child. Council properties, again, don't forget about don't forget about transfer of tenancies, because going back to K&K, I know it's a very old case, but you can get council tenancies transferred, albeit that you would need, as a solicitor, to ensure that you don't allow the other co-tenant to surrender the tenancy before you get your application in and before the court, because if they've surrendered it, there's nothing to transfer. So that would be very important for you to remember. But again, I just flag it up because it's under Schedule 1, that would be an application you could make. Then moving on, lump sum claims.
I just have to say, Claire, about the council properties, that's a very complicated area in practice, and also ones where there's been a discount on a right to buy, which can actually apply in quite affluent areas of London, where those properties were council tenancies many years ago and then pop up in expensive boroughs. And I think it's again about awareness, and it's quite a technical area of law, so not to be underestimated. No.
And I suppose you might get one client with the child negotiating with the local authority, if it was a larger property, to give up that property for a smaller property. You've got to just think strategically about what people might be doing or thinking about doing, and just be aware of not having someone get ahead of any claims that you might want to bring. But yes, it's just worth bearing in mind. But I agree with Graeme, it's not necessarily a straightforward area. Then just galloping on to lump sum claims, because you can be more creative about this. Don't think that you have to be big money cases. Green and Adams was a case, again, it's an interesting case. This is the father had really manipulated his financial presentation to avoid any maximum assessment being made by the CMS. So she couldn't get a top-up award. And the court was very critical of him because he had really, he was worth millions, but he had managed to portray his financial worth to CMS as being much lower than that, to the extent that he wasn't even a maximum assessment. This is because of the assets basis variation ground not being available. And so she was going to have to go to appeal on that. And so the court was very critical, but then looked at what was available. She'd previously had, I think in that case, property secured, so that's why that wasn't an issue. So this was a long-running saga. She was back for capital, and she wanted a new car. She wanted contribution to a school trip, a new laptop for the child, even contribution to the cost of a kayak for the kid. So Mr. Justice Mostyn certainly agreed that the replacement car was undoubtedly a capital expenditure that was appropriate, and on balance also agreed that the school trips, the laptop and the kayak were also appropriate items of capital expenditure. Albeit he said they were borderline, he still gave them. But it may have been that she was successful because actually she was just asking for a 50% contribution to the cost of the school trip and a 50% contribution to the cost of the kayak. Query whether he felt it was borderline and she'd been asking for all of it, whether she would have succeeded. But this case is also interesting, we'll come touch on it about it in relation to enforcement, but because the father had behaved so appallingly, the court made an immediate charging order secured on one of his properties, an absolute charging order, in order to secure the payment of the lump sum that the mother had sought, which was about 20,000, just because there was absolutely zero confidence that he was going to actually comply with the order. So the point is, don't forget about, it's a good case to read, it's quite a short one. I think that's one where Dr. Pelling was involved, so they're always an interesting read. Moving on, MT and OT, again, this is another case where the parties had been in litigation for a number of years. And so this was bite 2 of the cherries. That's what the father was trying to argue, because she was seeking replacement property, arguing that the property that had previously been provided by way of settlement wasn't appropriate to the needs of the young people as they were now, who were much older, etc. And the father was arguing, you can't have a replacement property, you've got one, you just have to stick with it. And the court was clear that no, she was basically rolling it over. It was still one settlement, but allowed to roll it over to a more appropriate property, together with lump sum to cover costs of moving, refurbishment of the property, again, all itemised appropriately. And because it was such a litigious case, she was also awarded a contingency fund to cover her legal fees, but that on the basis that would be repaid if not used. The court was obviously with an eye to the fact that these parents could not agree on anything, and the likelihood would be that there would need to be further applications or advice sought in relation to particular issues. And so because the mother was much more vulnerable and the father was extremely wealthy, this was felt to be appropriate. So again, just look at the types of provision that can be sought under Schedule 1. So summary, look at the standard of living between the households. Is there parity? Courts don't like to see a big discrepancy between one parent as compared to the other, because what does it say to the child about the value of both parents? Public policy, why should the state pay if the other parent can pay? Don't forget the welfare of the child, and then who benefits the child versus the carer. And that's always a thorny issue, because paying parents are always very concerned that the carer, who often the mother, is dressing up claims in her own right for the child when it's really straying into territory that's really for her. But the focus of this webinar is really more on the capital provision. And I think it's going to be obviously clearer that you can make arguments as provision being for benefit of the child rather than carer. Obviously, the carer's allowance cases are another area which are problematic. And so that's where those arguments, I think, will come out to a greater extent.
I was just going to say, Claire, that my experience is that that last point about carer allowances and perhaps provision through the back door, it's very contentious in practice, and that's because fathers feel that it's benefiting the mother rather than the child. But I think the other point, the earlier point that you make about parity between households, that's something that really I think is important across the board, irrespective of the formality of the relationship between the parents. It's really important for the children to see that. So it's about striking the balance, and that's where we are with the state of the law, I'm afraid.
Yeah. I mean, it'll be interesting to see whether there's any change in attitude in relation to that issue in the coming year or so. In terms of costs, I mean, I'm not going to go into great detail about this. Can there be a fighting fund? Because obviously there's no statutory provision under the Children Act for LASBOs, but the case law does provide for payment in relation to costs. It's considered to be a payment for the benefit of the child. And what you'd have to do is apply for an interim lump sum award using Part 18 procedure. But you'd have to look at the paying parents' resources, whether they can fund such a payment, as well as a substantive order. You're going to have to apply the Curry checklist. Has the parent with care got the ability to get cost provision in any other way? Do we need a level playing field? All these sorts of arguments. What's the merits of the substantive claim? What's the attitude to ADR been? All these factors are going to come into the mix. But again, with the sort of cases we're talking about, the bread and butter cases, this is going to be potentially an important issue where you've got parents separating and one parent, the caring parent, is more financially vulnerable. And is in need of provision, but hasn't got the ability to fund it. That's where you need to be considering all the issues that I've set out here, because the court certainly will consider that it is for you can make an argument and succeed in arguments that it will be for the benefit of the child, for the mother to be represented to argue for the child's benefit that further awards should be made. Costs. Again, this is general order of no orders to cost will not apply. So it's a clean sheet principle. Call to bank offers will be taken into account. And so it's going to be important to bear that in mind and to have it in the back of your head in terms of the way you approach litigation and the advice you give clients. That you need to be having one eye to the end of the case and pitching your offers appropriately. And it's a very fine balance where we're not used to doing it under the divorce provision area, although maybe that will change as well in time to come. But there's also, because it is for the benefit of the child, you might get orders being made for costs if financial hardship of one party does require it. So I've just galloped through that. I've set it out there because obviously you'll be able to download this webinar, so you've got the guidance there. But I
was just going to say, Claire, on a couple of those points. I mean, I think being live to the possibility of cost orders is the importance of getting that early advice, considering proportionality at an early stage, but also being aware of those earlier cases where the numbers don't seem too high. Mm-hmm. But the other point, which is about funding, I think it's really important to take that on board about the possible need to have to litigate to get the fighting fund, because I know that it's actually extremely rare to be able to get litigation loans for this type of litigation, that simply the loan providers don't generally want to make those sort of funds available. So it's a bit of a double whammy in terms of getting the funding right, and also having regard to costs.
Yeah, you can see from the litigation providers' perspective, why would you run the risk? They're not going to get a house potentially that they're going to be able to sell at the end of the day. So absolutely, which is where it comes back to your applications for LSPD kin orders are going to be important, because otherwise you have one hand tied behind your back. Arguably, you're running up debt on behalf of your client, which will form part of a claim potentially, but you don't want to be out on a limb on that as a solicitor. I wouldn't want to think would be something you'd be entirely happy with. So just practical considerations. Fact find with your client at an early stage. Get an understanding of the lifestyle that they enjoyed. Get the detail early, because then you can advise properly about what the potential claim is. And as Graeme says, get an idea of how proportionate the approach is. And the point is, although some of the cases indicate that the court, particularly where it comes to budgets, has a sort of broad brush approach. When it comes to capital provision of these sorts of cases, you are going to need it researched and evidenced, but always keeping a mind to the needs of the child and avoiding unreasonable claims for the carer's benefit. So, the more you can front load it just in terms of getting that information, it'll give you a better understanding in terms of getting the case in shape at an early stage and targeting what is going to be an effective claim on behalf of your client.
I'll just say, Claire, on that last point, that's a point I've picked up in practice a lot over the years. It's the temptation by legal representatives, I think also by claimants, to overplay that carer's benefit point as a route to try and bolster claims that don't exist in law, which is maintenance for the unmarried mother in her own right. We just don't have that in English law. And I think we have to be careful, particularly having regard to the other aspects just discussed about costs and things like that. Just at one point as chair of this webinar, for those who joined this a bit later than the start, just bear in mind there's a chat panel at the lower part of your screen. So if there are any questions or comments you wanted to raise, please do raise them, because we're moving into the latter part of the webinar and I can only pick them up if you raise them. Back to you, Claire.
Thank you. So just a reminder, it's Form A1 that you need to issue with, and you're completing a Form E1, which is obviously a more truncated financial disclosure requirement. Let's look at just practical issues, because obviously in the current circumstances, we need to be aware of the fact that you're probably not going to be going to court. Mr. Justice Mostyn's guidance needs to be borne in mind. It's going to be accelerated paper-only procedure in all likelihood. Look at the impetus and support that's now being given for private FDRs, for ADR as well, by any other means. The courts are under such pressure, and I'll come on to that in a little bit further. We really, the clear guidance is look at alternative routes for sorting this out, whether it's mediation or arbitration, etc. Because the reality is, in private law work, you're not going to be going to court. It's going to be Skype or telephone hearings is the likelihood. And remember, no physical bundles. It's all got to be e-bundles, and look at the e-bundles protocol. Judges are going to be working from home, so they're not going to have practical, they're going to have paper bundles sent. There's also His Honour Judge O'Dwyer's guidance for CFC, which has come out recently. Only the most urgent cases are going to be listed for an attended hearing, and urgent means interim maintenance, legal services payment orders, which I suppose in Schedule 1 you'd have to argue would be akin to that under an interim order application for a lump sum, freezing orders under Matrimonial Causes Act, enforcement orders. But even then, you're not going to, even for the urgent cases, you're not necessarily going to get through the door, because they're going to be triaging, and you're going to have to justify why it can't proceed by way of remote hearing. And everything is, where possible, going to be dealt with by way of written submissions, paper hearing, certainly for first appointments. And then, again, very clear, look at ADR as a route to dealing with these sorts of cases, because they're just not going to be heard. And just whilst touching on that, so go back, His Honour Judge Tolson, I don't know whether anyone will have seen it, he's just sent out guidance for June, which I saw yesterday, and he was making it very clear in the CFC there are only going to be a maximum of probably 10 courts sitting, and that's not a guarantee. The likelihood, obviously, is that public law cases are going to be given priority in terms of live hearings. They're going to have, in those 10 courts, there's only going to be one case listed. So the bun fight that used to happen at 9 o'clock in the morning, that's just not on the cards at all. They're very clear that video hearings, telephone hearings are going to be the norm. And so this is obviously the brave new world currently. And in terms of Schedule 1, ADR is going to be something that we're going to need to be thinking about very carefully, particularly where people are separating. Arbitration is something that will be particularly suited for this sort of work, particularly where you've got a conjoined Trust of Land Act claim potentially on the horizon, where people are splitting up, they own the property jointly. There might be arguments about the beneficial ownership or not, but even so, they might want to bring claims under Talata. The benefit of arbitration is that you would have an arbitrator dealing with both claims at one time, whereas obviously in CFC, etc., that is not possible. So that's why it is going to be important to consider these alternative dispute resolutions, because the courts are under such pressure. I just don't know quite how they're going to get through the backlog, let alone the new cases, which are undoubtedly going to be ready to file, ready to go at least before too long. So as I said, I've set out that guidance, and as Judge Tolson has sent out more guidance about actually attending at CFC. Then finally, enforcement. I've just sort of set out, I haven't got time to go into the detail of it all today, but just for you to bear in mind that there are ways of various different ways of seeking enforcement for orders. You would hope that you wouldn't have to be thinking about that at the beginning of a case, but as you can see in Green and Adams, sometimes by the end of the case you're going to need it, and so it might be sensible to think about that before the case finally concludes, rather than having to come back and try and get into the system once again. So that's the sort of the run through on Schedule 1 in the time of COVID. The point that I've been trying to get through, and I hope that I have succeeded, is for you to think about the fact that Schedule 1 is not just confined to the fabulously wealthy cases, entertaining though they are to read. Schedule 1 does apply to the bread and butter cases that you have coming through your doors every day. They are absolutely worth thinking about. Don't think that it's just the CMS, which is the route to providing support for a client. Think about whether they have any capital needs for the child that need to be met and should be contributed to by the other parent, whether for kayaks or housing. There's a range of things that you can do to support clients in that regard. Thank you.
Okay, so just to, before we wrap up, I've seen that there's a couple of comments in the Zoom chat, and somebody's asked, will slides be made available to attendees? Yes, I believe they will. And also this webinar, I believe, will be available to download subsequently as well. The other comment, which was about the labelling of the process of ADR, my understanding, Claire, if I'm right, is that it's been called ADR in the court guidance that's handed down, over which, of course, as practitioners, we have no control. My other understanding over the years is that ADR has mutated into DR, and I think the modern name for it is actually problem solving. But at the moment, amongst family law professionals, that's the new term for it. But in terms of the court guidance, it will say ADR. And of course, that court guidance isn't just to family law professionals, but also to the general public. So we have no control over it, but I think we know what it all means. And I think there will be much more of it in the future as that backlog clears. And I certainly think we should be making greater use of it where we can. So in wrapping up today's webinar, I just wanted to thank Claire Heppenstall for her clear and concise guide to Schedule 1 claims during the time of Covid-19. And that's not just relevant for the situation now, but also for the position post-lockdown and in the years to come, as we see the number of cohabitants and children born to unmarried couples continue to increase. Thank you everybody for remaining attentive during this long hot day. And that's it. Thank you very much. Goodbye.